Good afternoon, and welcome to this edition of Disability Chat. Today we will be launching a new series that will look at advanced planning for disability, health insurance, and other legal tools. In this session, Allison Bartlett, a resident disability expert, will focus on what at-risk and gene-positive individuals need to know to prepare for pre-symptomatic and prodromal HD. You can send a question at any time during the presentation. Just click on the chat feature in the toolbar, type your question, and hit send. Your questions will be seen only by HDSA and will be answered at the end of the session. This presentation will be available in about a week on HDSA's YouTube channel or by going to hdsa.org/disabilitychat. On November 19th, our chat will explore what individuals need to know to prepare for early stage HD. And on January 14th of 2021, next year, our chat will focus on what you need to know to prepare for mid to late stage HD. Now, a little bit about our speaker. Allison Bartlett is HDSA's Manager of Disability Programs and is a disability attorney who specializes in representing clients with rare chronic conditions like HD to navigate through the complex disability system. Allison holds a JD from the University of Cincinnati College of Law and a BA in International Affairs from James Madison University. And now I'll turn our chat over to Allison.
Thank you, Deb, and thank you everyone for joining us this afternoon. I apologize, we had a little bit of technical difficulties, but we're all here now. So today I'm going to discuss the legal and disability considerations when preparing for prodromal and pre-symptomatic HD. So with legal preparation, I'm going to talk about asset protection, estate planning, and power of attorney and guardianship, or what I'm going to call legal decision making. I'm also going to discuss disability and other insurance, and this will include public insurance benefits and disability benefits, private benefits, and employer-provided benefits. So first, why does legal preparation matter? Well, without proper legal documents, the HD-affected individual could fall through the gaps in the legal and healthcare systems. This includes getting into legal trouble, like civil, criminal, or bankruptcy. There's been a lot of times I've worked with HD families because someone has gotten into criminal trouble as a result of their HD symptoms, and people didn't really disclose the HD diagnosis to the lawyer or any relevant people in the process, or they didn't have someone who could speak on their behalf, and so they ended up going to jail for something that might have been avoided. If you don't have proper legal preparation, you could also not be able to afford or access proper care, or you could be denied access to essential government benefits. And the reason we're talking about this now, and this needs to be done as soon as possible, is because proper legal documents take time, planning, and cognitive awareness. So with HD, if you are the individual with HD, as your condition progresses, your cognitive awareness is going to go down, and there's going to be a point where you legally can't sign documents anymore, and we don't want that to happen. And the more options you have in this process, the better able you'll be to make decisions when the time comes. And you don't want to have to worry about spending down assets in order to get the benefits you or a loved one needs. And this is important to note, because let's say someone's on Medicaid. Medicaid does want to get paid back once the person passes away, and often this could mean that Medicaid will take the family home as repayment unless these preparations are put in place. So that's why we're going to talk about this today. So the first thing we're going to talk about is asset protection. Why does this matter? Well, there are a number of different government benefits that look at resources and assets. Legally, they're usually called assets. For government purposes like Social Security and Medicaid, they're often called resources. So federal programs that have resource limits, well, Supplemental Security Income, or SSI, you have to have less than $2,000 in resources for an individual or less than $3,000 in resources for a married couple. For Medicaid, resource limits is $2,000 for an individual, and they have a 5-year look-back period. So they will look at all of your resources and assets for the last 5 years. This is not the case if you get Medicaid through SSI, but if you're applying for Medicaid once you reach an older age. And Medicaid's important because some of the important benefits are long-term care, in-home care. It could help pay for an in-home health aid. And so a lot of people benefit from being on Medicaid, and so it's essential to understand these resource limits. Food stamps have a resource limit, and that's $3,250 for households with an elderly or disabled member. I know a lot of individuals with HD who get SSI end up needing food stamps, so this is an important thing to know. Housing assistance also counts certain assets over $5,000 towards income. There are also state programs that look at your resources and assets. There's a temporary assistance for needy families. There's a number of different reasons why you might need this resource, but their limits are set by states and they range widely, but it could be as little as $1,000 in some states up to $10,000 in states like Delaware. And then there's also something called the Low Income Home Energy Assistance Program. 12 states have set asset limits, and most of which are below $5,000. So all these things are important because if you're living, with limited income, or if you're relying just on government benefits, then you might also need some of these other assistance programs to be able to continue to live comfortably, stay in your home, afford your bills, things like that. So there's a lot of different programs that look at resources and assets. So what is a resource or an asset? It's cash, bank accounts, stocks, U.S. savings bonds, it's land and property. So in most cases, they don't include your home as an asset where you live, but they will include any other property. So rental property, vacation home, a timeshare. You could own a piece of land in the middle of nowhere, and that could still negatively impact your case. I worked with someone who shared a piece of land with her brother. It really wasn't worth that much. No one wanted to buy it, but they couldn't get rid of it, and so it meant she couldn't get additional SSI benefits. They look at vehicles. You're only allowed one vehicle per household. So if you're married and you have 2 cars because you each have a car, that second car is going to count as an asset. They look at retirement accounts like an IRA, a 401k if you have any other kind of private account. They look at life insurance policies over $1,500, all of your personal property. So like an iPad, an iPhone, things in your home, jewelry. They look at burial funds over $1,500. Anything that you own that could be changed to cash that could be used for food or shelter counts as an asset or a resource. And some also use deemed resources. So Social Security or Supplemental Security Income looks at deemed resources. And a deemed resource is a portion of a resource of a spouse, parent, spouse, sponsor of an alien, or sponsor's spouse. Related to the person applying for SSI, and so a portion of any of their income or assets is going to be deemed on you. So this happens a lot if you are an individual. Let's say you're a 19-year-old, you're living with your parents' house, you're living at your parents' house, you've applied for disability, and you don't help pay the mortgage, you don't pay for any bills. Even though you're now an adult because you're not paying for anything, your parents' resources and assets are going to be deemed on to you. And in a lot of times that could disqualify somebody or it could greatly reduce their benefits. So what are different asset protection options? There are trusts, caregiver agreements, able accounts, and estate planning, just to name a few. So a trust is a financial agreement that allows a third party or trustee to hold assets on behalf of a beneficiary or beneficiaries. Trust can be arranged in many ways and can specify exactly how and when the assets pass to beneficiaries. So there's 2 kinds of trusts. There's 2 main kinds of trusts. There's other kinds of trusts, but I didn't want to overwhelm people, and this is like the most relevant information. So the 2 main kinds of trust are revocable. This is also known as a living trust. It allows you to retain control of the assets during your lifetime. So if I create a revocable trust, I retain control of my assets. It's flexible and can be dissolved at any time, but because I maintain control of everything, I cannot use this to protect assets from Medicaid or Social Security. An irrevocable trust, on the other hand, transfers your assets out of your estate and potentially out of the reach of estate taxes and probate and Social Security. Once you establish the trust, you will lose control over the assets and you cannot change any terms or decide to dissolve the trust. But this is used to help with Medicaid eligibility because they avoid the necessity of spending down assets. Because if it's in an irrevocable trust, it's no longer counted as your asset. It could still be used as your benefit. It can still be used to help pay for your rent or other things, but it means someone else controls it and gets to make the ultimate decision about that money, which is why it's not counted as an asset anymore. There are a lot of different kinds of trusts. And so if you do want to get a trust, you are going to need to speak to an attorney that specializes in trusts. The laws by state are different. It's very variable. It's very complex. And in addition to just trusts, there are a number of different kinds of specialty trusts that are especially applicable for people with disabilities or HD. So number one is a special needs trust. This trust is meant for a dependent who receives government benefits such as Social Security, disability, or Medicaid. Setting up the trust enables the disabled person to receive the income without affecting or forfeiting the government payments. This is a really good option if a parent wants to leave money to a child with HD, or if, say I have two siblings. Let's say that my brother has HD, and I know when I pass away, if he's still alive, I want to leave him some of my money. And so knowing that, I would want to create a special needs trust, and I would put that inheritance in that trust so it doesn't impact his benefits, it doesn't impact his ability to continue receiving benefits, but he would still be able to use that money for his care, either for his doctor's appointments or to help pay his rent. You can control what that special needs trust is used for, but the government doesn't count it as an asset. And so it means the person can still continue to get care. You can leave money to them, but it's not going to impact their benefits or their ability to continue receiving their benefits. There's also something called a Medicaid Asset Protection Trust. This enables someone who would otherwise be ineligible for Medicaid to become Medicaid eligible and receive the care they require at home or in a nursing home. Assets in this type of trust are no longer considered owned by the Medicaid applicant, and these can also protect assets for one's children and other relatives, which is a win-win for Medicaid applicants and their families. And then there's also something called income trusts, and this is a type of special purpose trust that can be helpful to Medicaid applicants in states that have a set income limit for qualifying for Medicaid. Medicaid, even though overall it's a federal program, is run by each individual state, so every state has different criteria. And so there's different income limits for different states. And an individual's excess income is directly deposited each month into a restricted funds account, and then the money in the account can only be used for a specified reason. So all of these different kinds of special trusts allow you or a family member or a loved one to be able to get the care they need, still have money to provide for their care, but it won't jeopardize their benefits, which is really important because HD and care for HD can be very, very expensive. So another thing that you can use is a caregiver agreement. A caregiver agreement is a way of compensating family members for the care they provide. And this helps avoid the Medicaid penalty period that can result from transferring assets to family members. So again, Medicaid has that 5-year look back. If you transfer money to your family for any reason during that 5-year period, it can reset that 5-year period. And a caregiver agreement can help avoid that issue. So this agreement is a contract, typically between a family member who agrees to provide caregiver services for a disabled or aging relative and the person receiving care. It is an effective way of giving back to those who provide care while also reducing the Medicaid applicant's assets and therefore making them eligible for Medicaid sooner. If you don't have this agreement, payments to a caregiver will be considered a voluntary transfer of assets. It'll be considered a gift, and there will be a penalty period. So if you know you're ultimately going to be the caregiver for your loved one with HD, put it in writing. And even if it's a minimal amount, but you're getting a minimal amount every month to make sure they meet Medicaid eligibility requirements, this will help that process. And a caregiver agreement has to have 3 basic requirements for a person to pay a family member for care. The agreement must be in writing. With the law, it's always better to have everything in writing. I tell that to everyone. Doesn't matter what the issue is, I always tell you to have it in writing. The payment must be for care provided in the future. not for services already performed, and compensation for care must be reasonable. This is really, really important because Social Security, Medicaid, the law looks really, really carefully at this. So you should not be paying someone more than what you would pay a third party for the same care in your state or geographic area, and tasks performed should match reasonable or customary fees typically charged for those services. You also want to include a couple different things in a properly drafted caregiver agreement. You want to state the date that the care is supposed to begin. You want to provide a detailed description of services to be provided. So let's say you're going to provide transportation and errands. Well, what does that include? Driving to medical, dental, adult appointments, adult daycare and other appointments, food preparation. Include how often services will be provided. Allow for flexibility in care needs by using language such as no less than 20 hours a week or up to 80 hours a month, because we all know life changes. Sometimes something comes up one month or different, and so you don't want to tie yourself to really strict criteria that you won't be able to meet. You want to include how much and when the caregiver will be compensated. You want to include how long the agreement is to be in effect. The agreement should set time, such as a year or 2 years, or even over a person's lifetime. If you're not sure, be general and say over a person's lifetime. If you know specifics, give specifics. A statement that the terms of the agreement can be modified only by mutual agreement of the parties in writing. So if you need to amend it, both of you agree to sign it and review the agreement. The location where the services are to be provided. So allow for the location of the care to change in response to increasing caregiver needs or care receiver needs. And it needs to be signed by both of the parties, and both of the parties need to date the agreement. So if I agreed with my mom to provide care for her, both me and my mom would need to sign the agreement. Next is an ABLE account. You might be more familiar with these, where these are being more talked about now as an option for families. So ABLE accounts are tax advantage savings accounts for individuals with disabilities and their family. The beneficiary of the account is the owner of the account. So if I'm the one who's disabled, I would be the beneficiary and the account would be in my name. And income earned by the accounts will not be taxed. The one thing with ABLE accounts is it only applies to individuals with disabilities that whose disabilities started before they turned 26 years old. And so this is applicable to younger adults. So if you have HD and you did not become symptomatic until you were 45, you're not going to be eligible for an ABLE account. But if you have a child with JHD, they will be eligible. Or even if you're somebody who's 22, and you start becoming symptomatic with HD, you'll still be eligible for an ABLE account. So if you're under 26 and receiving benefits through SSI or SSDI, you're automatically eligible to establish an ABLE account. You could still be eligible to open an ABLE account if you do not meet Social Security's, if you're not receiving disability yet, but if you meet Social Security's definition of disability. And you can prove this by getting a letter of disability certification from a licensed physician, so an MD or a DO. You can be over the age of 26 when you start your ABLE account, but you must have had an age of onset before your 26th birthday. So let's say you were found disabled at the age of 22 and you don't decide to open an ABLE account until you're 28. That's okay. You can still do that in that circumstance. And so are there limits to how much money you can put in an ABLE account? The total annual contributions by all participating individuals, including family and friends, for a single tax year is $15,000. State ABLE limits range from $235,000 to $529,000. It is important to note that if you're receiving SSI, you cannot have more than $100,000 in your ABLE account at a time. Otherwise, your SSI benefits will be paused until your account falls below the $100,000 limit. So what expenses are allowed by ABLE accounts? A qualified disability expense means any expense related to the designated beneficiary as a result of living life with disabilities. So this includes a lot of different things. It includes education, food, housing, transportation, employment training and support, assistive technology, personal support services, healthcare expenses, and administrative services. Essentially, these are expenses that help improve health, independence, and quality of life for the disabled individual. So the last thing within legal planning is estate planning. So what is estate planning? It is making a plan in advance to indicate who will receive your possessions, what you want them to receive, and when you want them to receive your possessions. Estate planning should also include instructions for passing on your values and valuables, instructions for your care if you become disabled before you die, naming a guardian for minor children, providing for family members with special needs without disrupting government benefits, providing for the transfer of your business at retirement, disability, or death, life insurance, disability income, and long-term care insurance, minimize taxes, court costs, and unnecessary legal fees, and it should be an ongoing process. People get in trouble because they don't update their will. Not only do you need a will, you definitely need to update it. So let's say you write a will when you have your first child, but then you have 3 more kids, you haven't updated your will, and if something happens to you, okay, so you know where your first child's gonna go, who's gonna care for your first child, but then the court has to make assumptions about who's gonna care for your other 2 children, and you don't wanna be in that circumstance. You don't want anyone else getting to make those decisions for you because they may not respect your wishes because they don't know what they are. So, why is estate planning important? If you do not have an estate plan, if you do not have a will, your state already has one for you. So if you're disabled, if you become disabled, you can no longer conduct your own business due to mental or physical incapacity. In that case, the state will appoint a guardian or conservator to control how your assets are used for your care. Sometimes this means control is given to someone outside of your family. This can be an expensive and time-consuming process, and the process is open to the public, so technically anyone could be involved. If you do not have an estate plan upon your death. So if you die without an estate plan, your assets will be distributed according to the laws of the state. In many states, if you are married with children, your spouse and children will receive a share of your assets. Spouse may not receive enough to live on. Or if you have minor children, the court could control their inheritance and choose a guardian for you. This also only includes your current marriage. Let's say you were married before. Let's say you don't have HD, but you were previously married to somebody who has HD, and you intended to provide for their care still upon your death. Well, if you're divorced, like they were to help them get additional benefits and care provided, and then you got remarried and you died without a will, the previous spouse who has HD isn't going to get anything because you didn't specify it, you didn't create a will, and that's not how the laws of the state work. So who is estate planning for? Everyone. Estate planning is for everyone. Everyone should do it, regardless of age, income, or wealth. We cannot predict what will happen in life. We cannot predict how long we will live. Despite what we like to think, we are not invincible. And I know a lot of people have trouble talking about estate planning, we should stop saying it's preparing for our death, because that's not what it is. It's preparing to make sure everyone we love is taken care of. Being afraid of death, that should be irrelevant in this process. It should be more about making sure you're taken care of, yourself is taken care of, and the people you love are taken care of. Especially because good estate planning is often most beneficial for families with modest assets. As I stated before, HD is a very expensive disease, and estate planning helps prepare for these costs. So what documents should be included in an estate plan? You should include a will. This is a legal document that coordinates the distribution of your assets after death. You should include a living will, otherwise known as an advance directive. This is a legal document that tells others what your personal choices are for your end-of-life medical treatment. I have included a link to a website called prepareforyourcare.org. This is a wonderful website that uses different state regulations to help you create an advance directive that you can print out. The website helps you do everything, and so it's a really good tool to help you create an advance directive. If you have HD, you're also going to want a power of attorney. And this is someone who provides This is a legal document that gives one person the power to act for another person. The document can grant broad legal authority or limited authority. You're also going to want a medical power of attorney. And this is a legal document that gives one person the authority to make tough medical decisions for another person. Now that we've talked, and this leads me right into legal decision making. So the reason you want these things in a will, and now we're going to talk about what they are. So legal decision making is appointing someone to act on your behalf to make legal, financial, and medical decisions. And this includes power of attorney, medical power of attorney, guardianship, and conservatorship. So legal decision making. Why does it matter? If you do not give a specific person the ability to act on your behalf, you may lose that right entirely. Someone could be appointed to make decisions for you that does not know your wishes or you. So with HD, because of the nature of the progression of the disease, if you have HD, ultimately you are going to lose the ability to make decisions for yourself. And so what I have seen, what can happen is you may lose the ability to make decisions, but you are not disabled enough for someone to be appointed to make decisions for you. So you fall into legal holes in the system. So you can only sign a power of attorney document if you have the cognitive and mental capacity to sign that document. But you may lose that capacity before you would actually be found incapacitated by the state. So what happens? You could become homeless. You could be denied essential benefits because you cannot complete the application, but legally no one can help you because you did not appoint a person, you're not in a mental state to ask for help, and no one can do it for you. Or you could stop getting important medical care, which could cause an even greater spiral. It could make the symptoms worse. I've seen a lot in my years as a disability attorney. And unfortunately, I have tried to help many people who have fallen into these gaps. Like if you do not create a power of attorney, if you do not appoint someone when you have the chance to, you will lose that ability. And then no one in your life, no matter how much they want to help you, can help you. So with this is just a nice little chart to really show the difference between power of attorney and guardianship. Power of attorney is something you choose. It allows an HD individual to appoint a person to manage their affairs, and it can be revoked. If for any reason, like if you get divorced or something happens and you don't like the person who you've appointed to act as your power of attorney when you become incapacitated, you can change that. And the power of attorney can be written so it only takes effect when the HD individual is no longer mentally competent. But with guardianship, this is when an adult with HD is deemed incapacitated by a state in a legal proceeding. There is no consent from an HD individual. You have lost your ability to consent. And the state, whatever state you live in, has found that you have lost your ability to consent, you've lost your ability to make any decisions to care for yourself, you've lost your ability to care for yourself, so someone else has to do it for you. When that happens, this takes effect immediately upon the court ruling and is very difficult to revoke. Generally, it's a family member who tries to do this, but if there's no one in your family, if there's no one left to take care of you, the courts will just appoint a guardian ad litem to do this for you. And so you've kind of lost say in what decisions are made because you didn't write them down. They're not going to know your wishes at that point. So with the power of attorney, there's a couple different kinds of power of attorneys. There's a general POA, which gives broad powers to a person to act on your behalf. These powers can include handling financial and business transactions, buying life insurance, settling claims, operating business interests, making gifts, employing professional help, like if you need an in-home nurse, buying or selling a house. A general POA is generally the kind of POA you want to include in an estate plan. A special POA is something that grants specific powers that a person can do on your behalf, so it's a lot more limited. Common powers include selling property, managing real estate, collecting debts, and handling business transactions. It might be like a one-off thing. Or let's say if you have a business managing real estate, you give someone a power of attorney to be like, hey, you have the authority to sell these properties on behalf of this organization or on behalf of me because I can't do it all the time. So that's just for specific things. If you have HD and you want to give a power of attorney to somebody, you're going to want to give them a general power of attorney. Otherwise, things may come up and they won't have the ability to make those decisions for you. And then with a healthcare power of attorney, it gives power for a person to make medical decisions on your behalf if you are unconscious or mentally incompetent. And so in addition to having a general power of attorney, if you have HD, you're going to want a general durable power of attorney, because the durability provision keeps the power of attorney in effect when a change happens. So let's say you create a power of attorney and you say this can only come into effect once you become mentally incompetent. This is something that is going to happen with HD. Well, you can specify in the document that it cannot go into effect until a doctor certifies that you are mentally incompetent, and you can also determine what doctor says that. So let's say you're going to an HD Center of Excellence. Let's say you're seeing Dr. Kostick at Ohio State. You could put in your power of attorney that the power of attorney document only becomes active once Dr. Kostick determines you've reached a certain, like you're no longer mentally competent to make decisions and care for yourself. And so that's when it would become active. And I think that's what scares a lot of people about getting a power of attorney. They assume once you sign the document, it becomes effective immediately. No, that's not how they work. That's not how you have to write them. It's more to protect you in the future when that happens. Because if you don't have it in place and you start to have issues making decisions for yourself, doing things that you need to do to take care of yourself, it's kind of legally past the point where an attorney is going to want you to sign a power of attorney. They're not really going to trust you to sign that document, because somebody could always come back and say it was signed under duress, or you were manipulated into doing it, you didn't have the thought process or the wherewithal to do it, and that could nullify the power of attorney, and someone else could get care of you that you never wanted to get care of you. And then guardianship versus conservatorship. So this can be a little confusing because there isn't a standard definition. So guardianship generally gives a person control over the personal day-to-day decisions of your life, or it applies to the care of a minor. And then conservatorship gives a person control over the financial and legal decisions, or it could apply to the care of an incapacitated adult. In some states, you could have a guardian and a conservator. So you could have someone who has control over your personal day-to-day decisions, and you could have someone who's in control over your financial and legal decisions. That can get complicated if your guardian and your conservator don't agree on things. So again, having a durable power of attorney can help prevent that from happening. And like, this happens. Having to get guardianship over a loved one with HD is definitely something that comes up. It's always a possibility. And generally speaking, it's from a family member who really cares. They're concerned about the person with HD's well-being. They want to make sure they get the care that they need. And so usually it's coming from a good place. That doesn't always happen, or if the HD family members are all dead or they don't know where they are, you could be given to care of the state. And then they have certain duties and obligations they have to abide by. It is legally defined, but it's not the same thing as being cared for by somebody that you trust and knew and kind of had some idea of how you wanted to be cared for. So now I'm going to talk about disability and other kinds of insurance. So why does it matter? Why do you need to get these things in advance? If you do not prepare in advance, you may miss out on benefits that you're entitled to, and it can create financial difficulty if proper policies are not in place. So the national average for a Social Security disability decision is 6 months, but the process can take years. I don't want anyone to be without any kind of income even for 6 months, because that's a really hard burden. But you have to have the right disability in place if you're going to avoid any kind of time where you don't have income. And you want to be able to access health insurance in order to get proper care. So you cannot get Social Security disability if you have no medical care, if you have no medical records. And so it's really important to have health insurance so you can get medical care, so you can ultimately get Social Security disability. So first, I'm going to talk about public insurance benefits. So this includes Social Security. There are two kinds of Social Security benefits. There's Social Security disability insurance. This is the better program. It's more stable and it's going to provide more benefits. So you're eligible for this program by earning work credits. You can earn up to 4 work credits per year. It takes $1,410 to earn 1 work credit. And each year, the earnings needed for 1 work credit goes up slightly. So sorry, I'm doing math in my head. Let's say you make about $60,000 a year. That means you've earned almost all of your work credits just by getting paid in the month of January. So it's not based on like throughout the year. If you earn all about $5,600 by the month of February, then you're good. They don't like make you have to, they don't look at all the income throughout the year. As long as you meet that like $5,600 mark, you're going to get all 4 work credits. Why is it important to get these work credits? Because if you don't get them, you won't be eligible for Social Security disability. So what can impact work credits? So if you attend school and you do not work while you're attending school, that'll reduce the number of work credits you have. So let's say you become symptomatic with HD at the age of 22 and you've never worked, you're not going to be eligible for Social Security disability insurance because you never worked. Or let's say you work up until you're 30 and then you decide to have a family and you stop working to care for your children, that'll also impact your work credits. If you stay at home for 10 years and then you don't start working again until you're 40, but you become disabled at 45, you're not going to have enough work credits to apply for Social Security disability insurance. So it's important to take into those considerations. At this time, there are no exceptions. So I want you to be aware when you're planning for these things, what you like. If you decide not to work while you're in school, that impacts your disability eligibility. If you decide to be a stay-at-home parent, that impacts your disability eligibility. So it's important to have those conversations and be aware of those things when you're planning. It's also important to know that Social Security defines substantive work. So if you're earning more than $1,260 per month gross, that counts as substantive work. They also look to see if you've worked long enough at a location to fully learn a job. So it'll take you longer to learn how to be a disability attorney than it will to be a teacher, than it will to be a waitress or work retail. So they do look at the amount of time that you work at a job to determine if you're like an expert at that job. And that all factors ultimately into the Social Security disability process. And then there's supplemental security income. That's a financial need-based program. They only look at your financial resources and monthly income. There are no work requirements. But with that program, the max benefit you could get is only $771 per month. The maximum SSDI benefit is somewhere between $2,800 and $3,000. And so they're very different programs. There's also temporary state disability. Only a few states offer this: California, Hawaii, New Jersey, New York, and Rhode Island. So this is not really a benefit that's offered to many people. It depends how long you work in the state, and at most you're going to get this benefit for a year. For the most part, it's only 6 months. Benefits generally last 26 to 30 weeks. California is the exception with 52 weeks. So this is really a temporary benefit. This is to maybe help you get to your Social Security disability benefit. So this is not something you're going to rely on, and most people don't have access to this anyway. And then for public insurance benefits, for health insurance, that includes Medicaid and Medicare. Medicaid is health insurance for low-income and disabled individuals. Medicaid has been expanded in 38 states and Washington, D.C., which means any adult under a certain income criteria can get it. In the other 12 states that have not expanded Medicaid, non-disabled adults cannot obtain Medicaid. There is no insurance premium, and it covers important things like nursing homes, long-term care, and in-home health aides. Medicare is health insurance for individuals over 65 and disabled individuals. So Part A, Medicare Part A is hospital insurance. There's no premium. Medicare Part B is medical insurance, and that premium is $144.60 per month. and this does not cover long-term care. There are some exceptions. If you have very, very low income, you could have Medicare and Medicaid at the same time, and Medicaid could cover your Medicare Part B premium. So in certain circumstances, you can be eligible for both, but again, that means you're very, very limited in your finances, and we don't want you to be there. So private insurance benefits. So this includes health insurance. Health insurance helps cover the cost of medical expenses. Medical bills are a leading cause of consumer debt and related financial problems. With private insurance, you cannot be denied health insurance because of a pre-existing condition, thanks to the Affordable Care Act. But pre-existing conditions often require more expensive health insurance plans to ensure you can access the doctors and care that you need. A good place to start is healthcare.gov. You could also go to policygenius.com. Policygenius.com is a wonderful website that has all different kinds of insurance, from health insurance to long-term care insurance. It covers a lot of different things, and it's a good place to go if you don't really know anything about these kinds of insurance and you just want background information. It does also provide options to help you find the insurance that's right for you, but it's still a good place to start if you don't even know what you're looking for and you're overwhelmed. So life insurance. This provides a tax-free lump sum of money to replace lost income after your death. It often requires a medical evaluation or access to medical records to be granted life insurance, which is definitely an issue for families that have HD. Same goes for long-term disability. It helps replace up to 60% of your income if you become sick or injured, and can last until your retirement. You'd have to make sure the policy says it lasts that long. Some last 2 years, some last 5 years, some last 10 years. So it depends on the terms of your policy. So you have to make sure you read the terms of your policy. And usually you can only get private long-term disability if your employer doesn't provide it. In some circumstances, you can get an additional coverage if your employer only provides so much, or if you're self-employed. And then long-term care private insurance. So this is really beneficial because it pays for the cost of a nursing home and other kinds of elder/disability care. It does not cover the cost of surgeries, prescription drugs, or doctor's visits. Those are covered by health insurance. And then this is important because an estimated 3 out of 4 seniors will need some form of long-term care. And I've said before, Medicare, while it's automatically granted to all Americans at 65, it does not cover long-term care costs. Medicaid does, but you have to meet the very strict financial criteria. And nursing homes can be incredibly expensive. The national average is it costs $200 per day, but they can run up to $400 per day. So that's anywhere from $75,000 to $150,000 per year. A 5-year stay in a nursing home could easily cost over $750,000. This is why asset protection planning is important. This is why estate planning is important. This is why you need to have this conversation when you're young. So you need to have this conversation if you know HD runs in your family, but you haven't gotten tested yet because you're not ready to. You still need to start planning. It's always better to have this plan in place. So if you do get tested and you don't have HD, it's still good to have this plan because, again, you don't know you don't know what's going to happen. But if you don't start making this plan early and you have no plan by the time you become symptomatic, in a lot of cases, it's too late, or you're not going to be able to save up the amount of money or protect the number of assets you could have if you'd started thinking about this sooner. And the thing with private insurance benefits is if you answer yes to any of these questions, then the time has passed for you to be able to get private insurance. Are you symptomatic? Have you seen a neurologist? Have you had any documented cognitive issues? Those are all red flags to private insurance companies. And unfortunately now, most private insurance companies answering yes to having a family history of HD is also a precluding question. So it means they're not going to grant you these private benefits if you have a history of HD in your family. The other thing is it's really important to be open and honest when you're looking for insurance, because if you're not, let's say you fail to disclose something, like you've technically had documented cognitive issues, but you don't disclose that, the insurance companies can rescind the policy in place if it is given to you. And you don't want them to come back and sue you. You don't want to have to deal with that. So you cannot lie or conceal information. And the reason we talked about private insurance benefits is to talk about the importance of employer insurance benefits. Employer insurance benefits are the benefits you want to take if they're offered to you. If you are eligible for these benefits and you're not currently taking them, I'm going to come down there. I'm not going to do anything because I can't. But you're missing out on really important essential benefits that you could lose access to, and I don't want anybody to be in that situation. If your employer provides amazing benefits, take them. Take them, take them, take them. Usually the additional cost per month is not a lot. It's something you really seriously have to consider. So the kind of benefits your employer can provide are health insurance benefits. You cannot be denied health insurance because of a pre-existing condition. You cannot be charged more because of a pre-existing condition. Your spouse cannot be denied health insurance under your employer benefits because of a pre-existing condition, and they cannot charge more. Plans are standardized across the employer, and you pay based on the number of people in your family that need coverage. And again, family members cannot be denied because of a pre-existing condition. There might be other reasons they could be denied, like some companies, if your spouse can get health insurance through their own employer, they won't cover your spouse. So I'm married. I am offered health insurance through my organization. My husband's offered health insurance through his organization. I am allowed to get health insurance through my husband's organization, but some don't let that happen. Because I'm eligible for health insurance through my employer, some companies make each spouse take health insurance through their own jobs. Anyway, the other thing is getting health insurance through your employer means you'll also have access to COBRA. COBRA allows you to continue health care coverage from your employer if you have to leave your job due to a disability. So COBRA lasts 18 months, and you can get an 11-month extension if found disabled by Social Security to cover the 2-year Medicare waiting period. You will have to cover the cost of the entire premium. It won't be subsidized anymore, so it could be expensive, but it's something you have access to, and that's really nice. A lot of employers offer they offer life insurance. When this benefit is provided, you do not have to meet any medical criteria for the base policy amount. Some companies cover life insurance up to what your salary is, or they'll cover just a base of $50,000. If you want additional coverage, then you may have to provide medical records or a family medical history. But generally, if your employer provides life insurance as an option, you can get life insurance for that base amount, and nobody's going to ask you any questions. This is true of disability insurance as well. So short-term disability, this is only cost-effective when it is employer-provided. You could try to get private short-term disability benefits, but it's just not cost-effective. Generally, there are no criteria when this is employer-provided because you'll only get it for 6 to 8 weeks. Everyone should pay into this benefit. Another fun fact, most employers don't provide maternity leave, so short-term disability can be used instead if you ever decide to have a baby, because pregnancy is considered a disability, fun fact. Anyway, there's also long-term disability. It is important, so if your employer provides long-term disability, again, there aren't criteria that are going to exclude you from this benefit. It is important to read through the policy to know what limitations or exemptions may exist. For example, generally you have to pay into the policy for a year before you can receive your diagnosis and try to use the policy. Like, you can't start paying for long-term disability and immediately try to use it. Generally, you have to pay into it for at least a year before you can use it. The policy does not follow you when you leave your job. So if you're leaving an employer that's providing long-term disability, you need to make sure if you're going to another employer that they also provide long-term disability. And the policy cannot be used if you get fired. Sometimes the policies have weird limits in them, like they won't cover certain things, and you do need to ask that up front. It's important for you to be aware of what's included. But for the most part, if you get employer-provided long-term disability benefits and you've been paying into it for more than a year, you're likely going to be able to use it if you have to leave your job because of HD. And then retirement benefits. I'm talking about this because some employers require you to pay into a separate disability or retirement program in addition to Social Security. So that includes federal government jobs and some state government jobs. I know Florida is an example of that. And so what that means is if you have to leave your job because of a disability, you have to apply for disability through both of the different programs. And then there are other employers that require you to pay into a separate disability/retirement system other than Social Security. You need to know what you're paying into so you know where you're going to apply for disability for when you have to stop working because of your HD. So state governments all have their own retirement system. If you work for the state government, you're going to be paying into your own state retirement system, like the Florida retirement system or the Texas retirement system. If you're a teacher, you could pay into a separate program. In Ohio, you pay into the Ohio Public Education Retirement System, or OPERS. In Louisiana, you might pay into the Teachers Retirement System of Louisiana. And or you could pay into a special 403B retirement plan, and that's a retirement plan for certain public school employees, employees of some nonprofits, or some ministers. And so some of these examples are something called TIAA or Mutual of America, and you need to know what these are. Like if you do not get, it's not a W-2, but you need to know if you're paying into Social Security disability, because a lot of people just assume they're going to be able to get Social Security disability, but if you work for a job that's never paid into it, you're not going to be eligible for it. And you need to know that for your planning processes because the requirements are different. And a lot of times, if you pay into a private system like OPERS, they call it disability retirement. And so really it's just like they consider it you're just taking really early retirement because of a disability. And so the system looks different. It's also important to know that because if you pay into OPERS, you also are paying into Medicare, but not the financial part of Social Security disability insurance. You'd have to apply for both OPERS disability and Medicare. So you can see how that gets confusing. And to sum up, private benefits are often more expensive. There's more restrictions, especially for HD families, but they might be the only available option. With employer benefits, they're easier to obtain because if they're offered through your employer, they can't ask those questions. There's generally better coverage, but it's not offered by everyone. But like if your employer offers benefits, please take them. I don't care even if HD doesn't run in your family, take them. I don't care if you get the gene test and you don't have HD. I still want you to take these benefits because for legal and financial planning, these are the best decisions that you can make for your future. And again, I'm all about knowing your options. You can't know about your options if you don't ask the question, if you don't get all the information. So one thing I have done is, and to go along with this webinar, I created a checklist to help you plan for financial and legal preparation for prodromal or pre-symptomatic HD. Because generally, if you have prodromal or pre-symptomatic HD, you're a younger individual. You may or may not have gotten tested yet, but it means you're not symptomatic. It means you have time to keep working. It means you have time to kind of look at these decisions. And so it can help you figure out what you need to be looking for. So it's a resource for you to use to kind of put everything in one place so you can have and use it moving forward. And are there any questions?
Yes, Allison, we actually have several questions. And the first is from one of our attendees. What happens if a person appoints a power of attorney and loses some mental capacity and wants to revoke it spontaneously? At that point, if they are not totally incapacitated, can they still revoke it?
That's an excellent question. And that's hard for me to answer because every state has different power of attorney laws. And so your document would have to meet the laws of that state. I think it depends how thoroughly, I recommend working with an attorney, depending on how detailed you want to be, but I think it depends on how thoroughly you define incapacitation in that document. So let's say in your document you listed 4 things that have to be met for you to be found incapacitated. Those 4 things haven't been met yet. Maybe you're having more trouble with like memory or concentration, but you haven't met the list that you set forth in your power of attorney, then you should be able to change who your appointed power of attorney is because those certain criteria haven't been met.
Right. Our next question is, how many total work credits do you need to apply? Or maybe for how many years in a row do you need to earn work credits? I'm not sure I understand.
That's a complicated question to answer because it depends on your age. Generally, if you're between the ages of 20 and 30, they break it down into years, so you have to earn a certain amount. I don't know the information off the top of my head. It's like you have to have 6 work credits if you're between the ages of like 18 and 22, and then it's different if you're between the ages of 23 and 26, and then it's different between the ages of 26 and 29. Maybe it goes up to 32. Any time after 32, between 32 and 65, you have to have 40 work credits. 20 of them have to be earned in the last 10 years.
Okay. So the next question is, so my 55-year-old mom was diagnosed as HD positive, so I'm at risk, 28 years old. My husband and I want to my husband wants me to get tested before having kids to determine if we should pursue IVF and PDG. What legal documentation do we need to set up before getting the test results in case I am HD positive?
So really, the only thing that it's hard now because they've changed the way private insurance works. Even just 2 years ago, private insurance would ask if you've been diagnosed with HD, but now they ask if you have a family history. And so that was really more important to get done before you got HD testing done. At this point, legally, you can get things done at any point. You don't have to only do it before you have a positive HD test. The only thing that really like a positive HD test caused an issue for was getting insurance, but now because insurance asks different questions, they ask about the family history instead of just if you have it, you don't have to have legal things done before you get HD testing if you're worried about having a positive HD test, because it doesn't matter what your status is when you write a will. It doesn't matter what your status is if you want to set up a special needs trust. Legally speaking, a positive HD test doesn't matter, but and in most states, I think except for Florida, because they're just changing the law for 2021, that they're not, you can't use genetic information to discriminate against getting long-term private insurance, like long-term care insurance or other disability insurance, but that's not how it works nationally. So fortunately and unfortunately, at this point, there's nothing you have to get done before you get a positive HD test because insurance companies have made it so difficult for HD families, regardless of their gene status.
So this one's a little more, this is also a complicated question. So my aunt, who is in mid to late stage HD and is 64 years old, is going through a divorce and has assigned me as her power of attorney. Due to the HD, I fear her decision-making is impaired. Do you think it would be more appropriate to get guardianship or conservatorship? And how do I go about doing this? And how long does the process take? Also, does a caregiver agreement need to be notarized? We are in the state of Florida.
I cannot answer if a caregiver agreement needs to be notarized because, again, that's something that's going to be state specific. Generally, it doesn't hurt to get things notarized because it means there's an official witness. So really, the difference between a power of attorney and getting conservatorship or guardianship depends on legally what you have the right to do in the state of Florida with that power of attorney. Does it give you enough of a decision to be able to make legal decisions for her? Or by going through the divorce, you don't have access to those legal decisions and you're concerned that she's not going to be fairly treated in this divorce because you can't make all of those legal decisions, then yes, you may need to get guardianship or conservatorship. It depends on how the state of Florida defines it. I'm not sure how they define it in the state of Florida. So what that looks like is you'd actually have to go through the court system in the state of Florida. You'd have to go, I don't know which court you'd have to go to, but essentially you'd have to file a legal claim like that, hey, based on my aunt's medical evidence, her diagnosis, and things that have been going on in her life, I don't think she has the ability to make decisions for herself anymore and to care for herself. Generally, the standard is someone will be deemed incapacitated by a state if it is found they can no longer recognize decisions. People are allowed to make bad decisions for themselves. It becomes complicated because a state has to find they no longer understand those decisions or have the ability to recognize or make the decision. If your aunt is at that point and you have medical documentation that can back that up, then maybe go through the process. The other thing is your aunt going to be upset if you try to get that control over you, because it is a legal proceeding and it does add complications. And so that's kind of a conversation you need to have with your aunt. Like, would she be okay with that? What powers are you granted through the power of attorney? Are you able to act as her voice in these divorce proceedings? Are you afraid the divorce is going to be unfair because of the limited power you have at this point? This is definitely complicated, and if you want to call me after, please do so. Because with legal things, legal complexities like these issues, there's a lot of stuff that goes into it. So I'm not going to, like, every person who asks me this question is going to get a different answer. Because as a good lawyer, my answer is always, it depends.
Okay, so another question is, I'm in a different state, but I had a patient who was going through a divorce, and she was appointed a guardian ad litem, not overall guardianship, but just for the purpose of divorce.
Okay. Okay. Do you know why the patient was granted a guardian ad litem? Like, while going through these proceedings, did a judge say, like, I question their ability to make their decisions? So a guardian ad litem is appointed if there's concerns the adult has trouble making decisions on their own, or needs someone else to kind of watch things. So usually in that circumstance, there's three people. There's the attorney, there's the individual with HD, and then there's the guardian ad litem. And the guardian ad litem's job is to make sure that the person with HD understands the proceedings, that the lawyer is adequately and accurately representing their wishes, and they're being properly cared for.
Okay. I think the information was basically just as an add-on to what you were saying. It was
okay.
My apologies. So the next question is, how should military retirees, either regular or medically retired, receiving monthly retirement protect their pay? Should they get tested before retiring so that it's documented in their records?
So unfortunately, I'm not really able to answer this question. This is something I've personally been trying to do more research on within the HD community because it works differently. So I've been working with the VA recently to kind of figure out more of this information, because with the military, there's their own set of rules. And so certain diagnoses like Parkinson's disease will get a presumptive finding of disability in the military. That's not the case with HD. So I'm going to try to do more research into that question. I don't have a good answer for you at this time, but get back to me and I'll try to find out more information so I'm better able to help military families.
Okay. I think we have time for just one more question. So do you have any suggestions on how to find a specific HD attorney in the state of New Jersey? What questions should I ask when looking for an attorney?
So when you say specific HD attorney, like, are you asking to represent you in the disability process, or are you asking about this for like other legal planning? Because you don't have to have a specific HD attorney. Like, you don't have to have someone who's like particularly knowledgeable about HD when you're going through the estate planning stuff, but it does really help to work with someone who works with patients with disabilities or special needs. One organization that I like is the Special Needs Alliance. I think they're a good organization to start with, and their website is just specialneedsalliance.org. They mostly specialize in special needs trusts, but you have to meet certain criteria to even be an attorney to get listed on their website as a resource, and I think they're a good place to start. No, I have not personally called all of the attorneys within this organization because I don't have that kind of time, but they work like the goal of their organization is to work with families who have disabilities and need other protections, and so they're likely to be more understanding. And so you don't have to get a specific HD attorney to be able to do these things. It's more, are you finding an attorney who already works, like who has familiarity working with the population that has disabilities or other special needs, because they're likely to be more understanding. And again, that's Special Needs Alliance, specialneedsalliance.org.
Thank you, Allison. We are running over, so I do want to just remind folks that if your questions weren't answered today, you can go to the HDSA website and click on the Ask Allison button, and you can pose additional questions to Allison through that vehicle. We are out of time now. I want to thank you very much for attending today, and remember that our next disability chat will be on November 19th, when Allison will be talking about what individuals need in order to prepare for early stage HD. Thanks so much and have a great day.